Welcome to Exhibits Marked. Back to our coverage of the domestic violence trial of the 90 Day Fiancé star Jeffrey Paschal. Paschal says the bumps and bruises found on his ex-girlfriend were self-inflicted, the product of a drunken, jealous rage. Let's take a look at that evidence and the other exhibits marked in this case. Two things I want to start with. First of all, still with us, civil rights and trial attorney Richard St. Paul. Before we start talking about those exhibits, just pointing out we are now on our jury verdict watch, 57 minutes, meaning that's how long the jury's been deliberating. All right, Richard, let's start with first. Evidence admitted, exhibits marked, and that are victims' pictures. Let's look at those together. We know that this court did say to the jury, you're going to get to take these exhibits with you to the jury deliberation room as you deliberate. And I have to tell you, I think some of these pictures are the first things they're going to look at. They're going to pick them up. They're going to hold them close. They're going to want to see. There's an example on the leg. It's very hard for me, Richard, to see a lot of marks and bruises versus that picture on the inside of the lip is very graphic. What are your thoughts about the significance or the weight of this evidence and these pictures that the jury will be able to look at?
So obviously the pictures, as we can see, looks like there is some type of damage, some type of bruising, some type of injury to the individual there. Now the question is, how was it caused? And the defendant says, well, it was from her self-inflicted. She was outside, fell, hit hard, and that's how it happened. But the thought is that there's no real, expert testimony as to, whether this injury could be caused by a fall or from, some type of assault. So that's interesting. So that could create some type of, reasonable doubt there if the jury believes the defendant's version of the fact.
So here's the thing. All right, so the defendant said that she ran into a door, and I think that you can see where the photo is and the picture on the bump on her head. There's a good argument to be made that could have been caused by a door, and then he said she came outside, fell into the bushes. That could explain the abrasions on her legs and her elbows. And there was a position taken by the defense team in this case that, listen, if he had really, for 45 minutes, like she said, taken her head and slammed it into the ground, the damage would have been a lot worse. Now, I know the burden is not on the defense. We know that, Richard. But the reality is, in my mind, if, in fact, that injury might have been caused by a door, wouldn't it be true that the defense could have chosen to call their own expert to provide that testimony?
No, of course, that is certainly true. And, the defense is, as you mentioned, the defense isn't required to do such thing because obviously the burden's on the prosecution. But I certainly would be, if that was part of the story, I certainly would be looking to, as a defense attorney, look to bolster my client's defense by calling an expert, and to testify as to these are the type of injuries that you can get from falling in the bush, from getting hit by a door. I think that certainly would help the defense tremendously.
All right, let's look at crime scene photos because we know a picture's worth 1,000 words, and it is something that in trial is a very good use. But listen, I don't know how compelling these crime scene photos are. We know that's blood spatter on the wall. The victim testified to that. There is more blood in the apartment. Yes, there is blood on the light switch, and this, based on the victim's testimony, is her blood. But unfortunately, the world that we live in and the trials that we follow, this is not a significant amount of blood. Do you think that this is potentially detrimental to the state's case?
Look, I certainly think so. Look, I mean, after you get an injury hitting your head, you certainly could be dizzy, going from side to side, hitting walls, trying to turn on lights. That certainly, you could have had some type of concussion. I certainly think that that particular type of evidence doesn't, necessarily show or take away from the defendant's testimony that she caused these injuries to herself. It also doesn't, necessarily take away from the prosecution that there was a fight going on or an assault and she was getting, tossed around from wall and, that there was some type of altercation taking place.
You're right.
So I think.
I didn't mean to interrupt you. Go ahead, Richard.
Oh, Oh, okay, sorry. So I think that it could play both ways.
And I was going to say, and I didn't mean to interrupt you, but that it could negate either one. You're right. So let's turn now to scratches on the defendant, because here's another set of pictures. They are what they are. I, again, struggled, especially in this picture, and there's one other, to see a lot of scratches. And so maybe if I had it right in front of my face, the picture, I might be able to see more. But again, I don't think this indicates significant scratching. Or what are your thoughts about these photos?
Certainly from the photos, it's hard to see. I mean, you certainly would need somebody to enhance it and point it out as the defense would need to do. But it's hard to see from with my eye here, taking a look at it, the particular scratches there. But as I said earlier, that could be helpful to the defendant to show, hey, not only was she self-inflicted, hurt herself, but she tried to hurt me in this jealous rage too. And look at my scratches.
All right. What I want to do now, please, is let's listen, because these are the exhibits marked. This is the evidence that the jury now has. So how did both sides argue this to the jury to convince them their version is right? Let's listen.
June 8th of 2019, they went and had dinner. Miss Wilson has never denied the fact that they went and had dinner, that she had alcohol. This whole case, we keep hearing about how much she had to drink. What you never heard was her deny that they went to dinner and she drank alcohol, not once. What she also told you is when they got back to the house after that, they planned on going and meeting some friends. They were going out to another bar. Nothing wrong with that. It's a Saturday night. But what you know now is that she never made it to that other bar. Because of this defendant, because of what he did to her. She didn't get drunk and fall downstairs or fall outside of her house. Ladies and gentlemen, the best thing you get to take back to that deliberation room with you is your common sense. We talked about it in voir dire. These photographs are worth 1,000 words. They're worth more words than any of us attorneys can possibly give you. She didn't fall into a door and get a knot the size of a fist on her forehead. She didn't fall into some bushes and have bruising on her hands, scrapes on her elbows, scrapes on her knees, bruises on her foot, bruises on both arms, scrapes down her back. She didn't fall into a door front and back, because she also has bruises on the back of her neck, scrapes down her back. That's what the defendant wants you to believe. He wants you to believe that this was all because she got too drunk.
All right, let's talk about this a little bit if we could, Richard, and what you just saw. What are your thoughts about closing arguments?
Look, I'm still not convinced that could not happen from falling down, hitting yourself hard on the door or falling into a bush. I'm still not convinced because the prosecution says it didn't happen that way. That's not enough. That's not enough for me. I don't think that would be enough for any juror. You have to line up the evidence, which is the testimony in this case, and the evidence of the pictures with your common sense, and that's the bottom line. So I think again the prosecution leaves room just because she says it, and again, this is closing statements. That's not evidence what she's saying.
Right.
So it leaves the door open for the defense to argue something different.
You're right, and you're right. It's not evidence, very important to remember, but can really sway a jury if done well. Let's listen to a little bit of the defense closing.
We are going to ask you to return a verdict of not guilty as it relates to Jeffrey Paschal on the first count of the indictment for aggravated kidnapping because he did not substantially confine her for her liberty. On count 2 for domestic violence because he did not assault her. And count 3 because he did not interfere with her calling 911. Thank you for your attention on behalf of Mr. Paschal.
All right, I'm compelled to point out, you could see behind the defense attorney a demonstrative aid that he used. And I just want to speak as to the fact that it too is not evidence. But look at that. What a great way to talk to the jury about the presumption of innocence. And you start on the far left, walk all the way across the room to the far right. And the state's burden is there beyond a reasonable doubt to convict. A great tool by the defense. And I know in this case, it's not evidence. It doesn't go back with the jury, but it sure is a compelling way to demonstrate, in my mind, to the jury exactly what the burden is. And Richard, I know that we need to squeeze in a quick break, but you're going to stay with me so we can continue to break all of this down.